Well, good afternoon. I am Arti, a professor at the law school, and I'm delighted to welcome all of you to yet another exciting installment of the Information Ecology series. Today we are delighted to welcome Professor Wesley Cohen of the Fuqua School of Business. As many of you probably know, he is a he's a very distinguished scholar, and he's also a professor of economics and management at the Fuqua School. He's also, in addition, a research associate of the National Bureau of Economic Research. Duke managed to lure Professor Cohen from Carnegie Mellon recently, and I know that was, we considered that quite a coup, because Professor Cohen has done pioneering work on the role of patents in incentivizing innovation. In particular, he's done some very influential work that has been cited widely on the relative importance of patents in different industries. This is empirical work that involved an extensive survey of R&D managers in different industries and identified the relative importance that patents have in terms of securing returns from innovation. He's also done some very interesting work on diffusion of knowledge from universities, for example, to industry. His most recent work is work that has been very influential to me personally, a very important empirical study of the role of patents on biomedical research. He's been tasked by the National Academy of Science. He was tasked by the National Academy of Sciences to investigate whether, in fact, these patents were incentivizing innovation or perhaps creating roadblocks to innovation, these patents on upstream biomedical research. And then last but not least, he's written most recently a very interesting paper that tries to do something really quite unique, which is measure in some concrete way how much incentives patents provide, the so-called patent premium in different industries, not just as a relative matter, but as an absolute matter. So without further ado, I could go on and on because his list of publications and presentations runs about 10 pages, but without further ado, I give you Professor Cohen.
Arti, thank you very much for your kind remarks, and moreover, I'd really like to thank the Center for the Study of the Public Domain for hosting my talk, and indeed this really fascinating, exciting series that really is, I think, has added a lot to the intellectual life of the university and really has galvanized a lot of attention on the issue of intellectual property, an issue which has become just more and more important over the past decade, and I think will continue to increase in importance. Today, I'd like to talk about some research that I've done over the prior several years, in fact, a series of papers, some of which have been alluded to by Arti already. And the papers really address the issue of patents, their effectiveness, and I'll talk about what that means, and their role in many settings, but particularly in affecting innovative activity. And this work has not been done alone. I've had numerous collaborators, Ashish Arora, Marco Ceccagnoli, Akira Goto, Akiya Nagata, Dick Nelson, and John Walsh, and it's benefited from the funding of Sloan Foundation, NSF, and the Center for Global Partnership, which is an affiliate of the U.S.-Japan Foundation. Let's start off with some background that I think you should all be familiar with. We have witnessed a strengthening and broadening of patent protection.
You need your wireless microphone.
Thank you. We have witnessed a strengthening and broadening of patent protection over the past now 20 plus years. Typically, although preceding this by a bit, the starting shot for this is typically dated from the 1982 creation of the Court of Appeals for the Federal Circuit. And we've witnessed since that time pro-patent trends in the courts. What do I mean by that? I mean clear increases in, for example, plaintiff success rates in infringement cases. We have also witnessed an expansion of what is patentable and who can patent. We know from early decisions in the 1981 Diamond v. Chakrabarty, Diamond v. Deere, announcing clearly the patentability in the former case of life forms, in the latter of software. Since then, in the 98 decision, well-known State Street decision, the patentability of even business methods. Okay, we have also witnessed an increase in standing of who can patent, notably since Bayh-Dole and related legislation through the early and mid-'80s. Now universities and other institutions receiving federal R&D support can now patent as well. What else have we observed? We've observed an increase in corporate patenting, growing from about 66,000 or so in 1980. In 2001, we had approximately 184,000 patents. Now, that growth is dramatic, obviously almost a tripling. It's not quite as dramatic as it might appear, because if you normalize the number of patents by R&D spending, really you find a sharp increase on the order of about 50% since the mid-'90s. But clearly that's a tremendous growth. We've also seen a growing emphasis in management on the exploitation of intellectual property, calls to patent more and assert the patents you have more aggressively. Some of you might be familiar with the volume written, I think it was published 2001 by Rivette and Klein, Rembrandts in the Attic, suggesting to corporate managers that they should poke around their R&D labs and patent what is worth patenting, and particularly to exploit a lot of patents that they had on hand. Okay, that's the background. There is, however, cause for questioning both public and private policies. Okay, the fundamental questions in both domains is, well, from a policy perspective, is this worth it? Are patents doing what they're supposed to do, namely really spur innovation and ultimately increase social welfare? Even from a narrower managerial perspective, okay, is, becoming more aggressive about patenting and asserting those patents, does that really benefit firms? Well, what's one cause for questioning this, and I locate myself really in the setting of some of this literature. We have a 40-year empirical legacy now dating from early work of Shearer and Associates in '59, going up through Mansfield, Levin, et al., and more recently the survey work that I've done with collaborators, is that patents are in fact not central to the protection of innovation in most industries. Okay, I put up there except drugs, and there's some others too, say medical devices, etc. But according to qualitative and then subsequently survey-based evidence, firms say that, hey, patents really aren't key to protecting my inventions. And I'll get into that in more detail in a moment. There's also been a growing concern over the impact of what's called the growing strategic uses of patents. What do we mean by that? We mean in industries like semiconductors or telecom, what we've witnessed are what amounts to patent portfolio races. Okay, firms are just increasing the numbers of patents often of questionable value, and these patents are really used in often for bargaining, as bargaining chips. And really, what's the return to that sort of activity? And at the same time, what kind of cost is associated with that? And are those patents that are being filed for, received, et cetera, are they really stimulating invention as they're supposed to do? Or do we have what could be characterized as a non-cooperative game in such an industry? The analogy might be the old story of when cigarette advertising was banned by the federal government. The U.S. tobacco firms complained bitterly, and they were very, very aggressively advertising cigarettes, et cetera. So, banned. They had to stop, and they went right over the objections of industry. What happened to the tobacco firms' profits? They rose precipitously. Okay? In other words, while each firm thought it was in its interest to advertise and so on, that doesn't necessarily mean that it was in the interest of the industry as a whole. Is that sort of dynamic occurring in the context of some industries with regard to patenting? There's also, as Arti alluded to before as well, some concern over the patenting of research inputs into subsequent discoveries, okay? That is where innovation is cumulative. So R&D, innovation builds on what has come before. If the prior step, if the prior discovery that's essential to subsequent work is patented, and their exclusionary rights asserted, or perhaps excessive licensing fees charged, what are the implications for very important downstream discovery and R&D? Take the example of Geron's patent position in human embryonic stem cell technology. Are we comfortable with such a broad platform for future research with Geron's position? It's now been narrowed subsequent to litigation, but still they exercise tremendous power over that area of research. Then there's the argument of the anti-commons that's posed in the literature as well. The argument here, for those of you who are not familiar with it, it's the argument, according really due to Heller and Eisenberg, is as the number of patents reading on a commercializable product increase, okay, it becomes more likely that development and commercialization will not go forward. Why? Because as there are more patents, there are more rights holders, okay, typically. And the question is can these rights holders be brought together? Can deals be made? Can negotiations be successfully achieved to allow perhaps a commercializable drug to go forward? And this has been raised particularly as a concern in the context of biomedicine, okay, reflecting at the time a great concern over the patentability of gene fragments, SNPs, CSTs, and so on, suggesting that, hey, to really develop a drug or a therapy that's based on these upstream developments, conceivably you have tens, if not more, of rights holders to those rights that you need to move forward with respect to just one therapy. Okay, I'm happy to answer questions on that theme later on. I've written recently along with some other folks on that, but I'm not going to focus on that today. Today, I want to just provide you with an overview of survey-based evidence on the effectiveness of patents in protecting inventions, and that's in the manufacturing sector, the US, and then I'll reflect a bit on Japan. I want to then extend that discussion to the uses of patents across industries. How do those uses vary? Are patents used in the same way? Do they have the same effect? Then I'd like to discuss what I call the quid pro quo. The quid pro quo is that, well, in exchange for the government giving you, a patent holder, the right to exclude, the government requires something in exchange. That is the disclosure of the invention, of its details, sufficient to enable others really to implement it. That's the quid pro quo. And what we've done is try to understand, are the information flows originating from those disclosures, are they significant? Are they useful? And we explore that in the context of a cross-national study between the US and Japanese manufacturing sectors. Finally, I want to discuss work that's really ongoing. We have a working paper on this, and it's about to become yet another working paper on this. The impact of patenting on R&D incentives in US manufacturing. You might say, well, you know, the provision for patenting as well as copyright is in the US Constitution really on the premise that such rights stimulate innovative activity, right? Is that true? I've just provided on the prior slide some reasons to think maybe not. Okay? And what's fascinating, at least what was fascinating to me years ago when I initiated some of this work, is that there's never been a systematic empirical study making that case. There's certainly strong reason to believe that's true in selected industries, particularly drugs and medical segments of the medical device industry and so on. But broadly across the manufacturing sector, that's not apparent. That's not at all. Okay, and I'd like to discuss some work on that subject where we've tried to make a little bit of headway. Okay. I once asked, shortly after I arrived at Duke, whether I might be able to change the name of this survey. I was at Carnegie Mellon for 20 years, hence the name, the Carnegie Mellon survey. And for better or worse, it was too embedded already in the literature, so I think that name has a life of its own. When we get funding for the next round, I'll call it the Duke survey, just to throw folks off. So anyway, the data that I'm reporting on actually was administered some time ago to R&D lab managers in the US manufacturing sector in '94. We received responses from almost 1,500 labs, representing a 46% response rate, though 54% adjusted. If you knock the guys out who really shouldn't have been in the sample to begin with, it ups our rate. The US sample was broadly representative of the firm size distribution, and that's an important issue. Okay. Prior work in this area, whether it was Mansfield or Levins and so on, had done similar surveys, at least a subset of the questions that we posed, at least questions that were similar to a subset, but only for larger firms. That is essentially Fortune 500 companies. Our survey really covers the map. We've got firms down to in fact, 2, 3, 4 employees. Some of those guys seem to be a little peculiar in answering our questions. So sometimes for purposes of analysis, we imposed a cutoff of about 10 employees or so. I will also, I would get letters from these folks, inventors, asking me if I could intervene with the USPTO to represent their various causes. It was quite startling. I'm also going to report on comparable Japanese survey. I coordinated this cross-national effort. The work in Japan was directed by Professor Akira Goto, who is now at the University of Tokyo. And we went through the procedures that you really do need to go through, which is, one, have someone who's Japanese doing it over there. Otherwise, you're toast for reasons that I could go into. But then we, of course, had it translated and then independently back-translated, et cetera. Actually, in the back translation and then in the subsequent piloting, though not the survey, we learned, Professor Goto informed me, Wes, we're going to obtain an extraordinary result. Okay. The extraordinary result is that although the Japanese national industries are actually at least competitive and sometimes beating American firms in any number of domains, they don't innovate. Okay. I'm going, all right, Akira, drop the other shoe. What are you talking about? Okay. And he said, well, we learned that the literal translation of the word innovation really connoted what we in English might call a breakthrough. Okay, so no one in Japan would ever say that they were doing breakthrough research as a matter of course. So we had almost no, quote, innovative activity in Japan. And finally, we said, okay, you tell these guys in their R&D labs that whatever they're doing, that's what we're talking about. Okay. So that suggests some of the challenges associated with not just translation, but really cross-cultural survey work. So thankfully, in the actual survey beyond the pilot stage, that was surely clarified. Okay, I first want to talk about the kinds of limits. Well, did I just jump back? Hang on. I did. I jumped over 6 slides. Okay. Let's try this again. Okay. Is there a technical man in the house here? Okay. I have it in front of me, so I could talk through it, but I want slide 6. Okay, where does it go down?
Let's say page down.
Page down, okay. Page 7, okay, yep.
Is that the right one?
No, go up 1, I should be on 6. 7, oh, did I skip 7? Okay, somehow 6 isn't showing up. Okay,
That's 5, right?
well, that should have been 6, our measure for effectiveness. No, that's okay. That's okay. Yeah. I think so. That's fine.
Are we all right?
I think so. Well, actually, go up 1.
Go up 1?
Yep. Data. Okay. Go down now to the next one. Why did that do that?
Is that still not right?
No, this is fine. That's
This
fine.
one's
Yep.
fine?
Yep.
So we can go with that one?
Yep.
Is that it?
That's it. Great. Good. Okay. Sorry for the commercial interruption there. First, I want to talk about patent effectiveness. And what's important here is to put patents in a broader context. That is, that there are in fact a variety of means that firms use to protect their inventions. Notably, in addition to patents, secrecy, lead time, complementary capabilities, though they may be marketing and sales capabilities, they may be manufacturing capabilities. And what we wanted to do is arrive at some sense of the relative effectiveness of each of these across the manufacturing sector in the US. Our measure of effectiveness was simply the percentage of firms' innovations for which one of these mechanisms was effective in protecting the competitive advantage from that innovation. If you asked respondents and firms to say, hey, tell us about which one of these mechanisms is more profitable in use than another, not a prayer, because they really don't know. But using the language of competitive advantage was much more transparent, though obviously a bit more difficult at times to interpret. We're back. Okay, what did we find? We found that the top mechanisms overall across the manufacturing sector were secrecy and lead time. And in fact, interestingly, when we compared our results to some similar results done in the mid-1980s by Levin et al., the surprising result was the relative jump in secrecy, which was down near the bottom of the barrel and close to patents back in the early mid-80s, but all of a sudden, firms said, hey, this is really important and very effective. Okay, so that was an interesting point of comparison. But there's a lot of cross-industry variation in the effectiveness of these different mechanisms, and notably of patents relative to other mechanisms. Okay. For example, we find that patents are relatively effective in drugs and medical equipment, much less effective in semiconductors and communications equipment. Another interesting result, contrary to my prior, I thought, I had kind of biotech in the back of my mind. So I thought that, small firms are going to find patents, are going to evaluate patents to be more effective than do large firms. Just the opposite. Just the opposite. Systematically, even controlling for industry, the larger the firm, the greater the likelihood that they would report patents to be more effective. How do you interpret these ratings? Okay. These are not mutually exclusive, and that's what's important to understand here. Just because somebody rates secrecy or lead time as a more effective mechanism for protecting invention doesn't mean they don't use patents. So don't believe that. Okay. In fact, they'll often use patents, and that's an interesting question. So really the way we interpret these results is a reflection of the centrality in the firm's broad strategy for protecting their inventions of each of these different means. And I think that that's the way you have to think about it. And I want to add, and this last point is very important, it bears on the last bit of research that I'm going to report on. Okay, patents are relatively less effective. People have taken my own results and said, Cohen and his collaborators say patents are less effective. That means in the preponderance of industries, aside from, drugs, medical equipment, etc., that, who needs them? What good are they? That's not true at all. Okay. In fact, that was really an open question, and it was that open question that stimulated some subsequent research on the part of some collaborators and myself to really try to address that question more systematically. What we know is that, relative to other mechanisms, sure, patents are not thought to be effective in the sense defined in the survey, but does that mean they don't yield a return? Does that mean they do not, therefore, incent R&D activity? It does not mean that. So you shouldn't jump from that first finding to a conclusion which is really not warranted. Okay. Here I just provide a nice table essentially providing for both products and processes an overview of the results that I just talked about. And you might find some things of interest here with regard to patents, and which is not at all surprising. Patents are thought to be less effective with regard to process than product innovation, and that was even well known in the literature before. Okay, I've some nice charts here with regard to the effectiveness of mechanisms in 4 selected industries. Drugs, I call biotech a separate industry, though it's not really a separate industry per se, but it's certainly, one could argue, a distinct technology and approach. Computers and semiconductors, validating essentially what I said before. You have patents in semiconductors. You have a percentage, 31% of respondents report that of it's 30 for, that we found in each of these industries that the percentage of product innovations for which, in this case, patents was considered effective was about 32% relative, say, to drugs, about 50%, and about 55% in biotech. Okay, and you can look at that. These, I believe, these tables will be available, I gather, over the web if folks are interested. Okay. Now, why do firms report that patents are less effective than one might believe? We asked firms, well, what are the most important reasons for not applying for a patent? Okay. One, the kind of simple answer was, well, it's not patentable. Okay. So that's really what demonstration of novelty reflects. And these are the responses to the question of what's the most important reason for not applying. The other two reasons, which I think are of greater interest, was information disclosure in the patent publication and the ease of inventing around the patent as well were quite important. I find this interesting, and this provides some insight into the prior result that I talked about, which is why do larger firms suggest that patents are more effective? I think it's right there. We observed a significant negative correlation between firm size and a reason for not applying for a patent, which was anticipated defense cost. Okay. Suggesting that I think it's reasonable to believe that larger firms thought patents were more effective. Why? Well, because they had the legal resources, they could afford the legal resources, and the more and more you learn about patenting, you learn that a patent's only as good as the number of attorneys you have standing behind it. Okay, and that's become very, very apparent. Okay. Now, let's talk about how are patents used across industries. And let's try to think about that, because that might be useful in thinking ultimately about the question of how might they, in fact, affect innovation. And this all started, really kind of probing this in detail, started due to a particular result that we came up with. And let me point to the result. These are in aggregate the reasons to patent for our aggregate sample. And prevention of copying, we thought that was kind of, in the survey business, that's called a socially desirable response. It's sort of mother and apple pie. Of course, you're going to check that one off. Patents prevent copying, although the same folks will suggest, no, it's easy to invent around. Okay, but they check that off anyway. Then things got more interesting after that. They also indicated, we asked them, think of the last innovation, significant innovation that you patented. What were all the reasons that you applied for a patent? And these were not mutually exclusive. So in addition to the prevention of copying, we had another one that I call patent blocking, that is preventing rivals from patenting related inventions. Clearly, for products, an enormous percentage of respondents indicated that. Prevention of suits, so defensive patenting, also quite important. Use in negotiations, also substantial. Licensing revenue, small relative to the other rationales for patenting. It was really the patent blocking result that caught the attention of someone named Mike Shearer. Those of you who know the literature on patenting, he's really one of the real pioneers in this area. And he said, Wes, and remember I was living in Pittsburgh at the time, he said, you know, this patent blocking result, you're in Pittsburgh. I know that's Pittsburgh Steeler country, and therefore you know what blocking means, okay? But I don't, okay? So thus started probably about a year of research in response to Mike Shearer's witty quip. And this is what we were tried to do over the course of that year, is understand if there were systematic differences across industries in the uses and functions of patents. And really, it began with this notion of blocking, okay? And I realized that blocking could really be done, if you will, in two ways. One, you could patent to block substitutes, okay, to something that you've patented, some core invention. And that could be done, and in the literature that's understood, building patent fences, if you will, to prevent someone else from imitating, from copying some core invention. For example, DuPont had 200 patents surrounding its core nylon patent. Okay, so they built a fairly impenetrable fence around that. But then patenting, blocking, there could be another sense of that. A sense of you're patenting to prevent someone else, in essence, from commercializing a complement, not a substitute. Something that you need, something else you needed to join with whatever you've got the patent on to go forward down into the market. What am I talking about? The different patentable elements in a computer chip, or more transparently, the different pieces of a computer printer, okay, or a computer itself. To go forward and actually commercialize something of that sort, you actually need access to not one or two, but sometimes in the hundreds or even thousands of patentable elements. So I realized that in response to Mike's question, there were two answers. Well, in one case, it might be that you want to stop somebody from exploiting a complement. In the other case, you just want to, foreclose substitution for your own core invention. And the key then, in my view, one of the keys in understanding differences and uses of patents across industries was this observation, that when the number of patents per commercializable innovation are great, it is unlikely that any one firm holds all the necessary rights. And what does that mean? That means you have a condition of mutual dependence, okay? And mutual dependence sets up a dynamic and a process of horse trading, negotiation. Everybody, all the parties realize their mutual interest, and everybody is hostage to one another, okay? And I also thought that, in fact, one could very coarsely distinguish across industries, and if you wanted to be more fine-grained, even within some industries across some segments, I didn't get down to that lower level of disaggregation. One could distinguish industries on the basis of how many patentable elements are there in a commercializable product. In drugs, by the way, in drugs, you think, oh, just one, rarely. It's more on the order of maybe 5, 10, 15, okay? But that's actually quite few. Because apparently, simple thing like the airbag, there's 1,500. According to a study that I read a couple of years ago, 1,500 patents that relate to airbag technology. Don't ask me what they are. In another case, where something I know a bit more about, Hewlett-Packard's inkjet printer basically entailed 500 patents, 50 patents on the little inkjet sprayer and the ink that went through it alone. Okay, and what happens there? It's unlikely in that sort of situation that any one firm in the market has all the rights it really needs to go to market. Okay, you have a condition of mutual dependence. So basically, I draw a distinction on that basis very, very coarsely between what I call complex and discrete product industries. Clearly, it's a continuum, but I just, for simplicity of analysis, draw a categorical distinction, where simply complex product industries are those industries where there are relatively more patentable elements than in discrete product industries. Okay. And Howard, do you use patents in complex product industries? What I call the strategy there is a player strategy, because in many cases, you're patenting in order to get access to the other guy's technology. IBM, in internal publications in 1990, said that that's why it was patenting. They were patenting in order to access all the other guys' rights. And so the more they patented, the stronger the hand that they had to deal with other firms. And so in those settings, you really patent to achieve what I call player status. You want a spot at the table. And it's literally a table in many industries where the usual suspects gather together and cut their, in essence, cross-licensing deals, marking up, how big is the portfolio. They'll typically mark up some handful, 10, 15, 20, whatever, what they call their quality patents. Lately, there's actually been a fair bit of money that it can exchange hands in those settings. Formerly, that was less typical. And so now there's somewhat more attention paid to what each firm thinks of as its quality patents. But even more fundamentally, what does this do? It wins you freedom to operate and design freedom via mutually assured destruction. And that terminology is often used in the industry itself. Okay? How does that work? Well, if they sue me, even if you don't have a cross-licensing deal, I can sue them. And nobody wants this. It's expensive. You really don't know where it's going to go. So you really have this, then the patent portfolio there acts in its mass to confer freedom to operate. Okay. In fact, there's a story there. With Texas Instrument in the memory chip market years ago in the 80s. It started suing first Japanese firms, then American firms. This is the kind of industry that fits with your definition, Wes. Why did you have this breakout of suits? Can anybody tell me? Any guess? Well, Texas Instrument at that time was absolutely getting killed in the memory market. Particularly by Japanese manufacturers. In essence, their assets, their plants were almost worthless at that point. Well, guess what? You were then out of a tit-for-tat sort of relationship. There was nothing that anybody could do to them. So what if they got sued in return and even got slapped with an injunction and had to shut down their plants? They were losing money anyway. Do them a favor. Okay, so at that point, they're out of the game. You don't have the mutual dependence anymore, and then there's an incentive to throw the first missile. And they did because they realized the way to make money in that setting, they did have assets in the form of intellectual property. And indeed, as was typical in that industry, that intellectual property was indeed being infringed. Okay, and they had nothing to lose being sued back. A more recent example, this is not arcane. Recently, DuPont, okay, although this is in a very different industry setting, but shows the importance of this sort of mutuality in guiding behavior. DuPont has an exclusive license over what's called the Harvard mouse, okay. Not long ago, they started, despite an agreement that they had cut a deal with NIH, they actually sort of started reading the agreement quite literally to the point of starting to sue various universities. Okay. Prior to that, they didn't do that. And why weren't they doing that? It's because they were actually actively pursuing research in biotechnology. It was only after they basically shut down that operation did they start becoming aggressive in asserting their patents. And the head of tech transfer, Andrew Neighbor at UCLA, said, but they're not in the business anymore. Why are they suing us? And the answer was, because they're not in the business anymore. They had nothing to lose. And the dependence there was really the dependence on the goodwill of university faculty and the reciprocal flow of information that in that setting of biomed goes back and forth and still does between firms and universities. So this notion of mutual dependence is really very, very important in understanding the way that patents are used or not. Okay. So in contrast to complex product industries, you have a discrete product industries where patents are used to, as I said, block substitutes by creating fences, not to block the use or commercialization of complements. Okay. Now, okay, this is just the logic. Sounds good, have some nice stories. What do you find? What do we find? Okay, here are we made a fairly coarse distinction in our sample between what we call discrete product industries and complex product industries. And we said, well, how are these patents used between the two? One reason for using patents is negotiations, and in parentheses on the survey it says, such as for cross-licensing. Okay? How are they used? Well, in discrete product industries, only 33% of our respondents said they used patents for the purpose of negotiations. In our complex product industries, 81%. This is not reading tea leaves here. These are not subtle differences. Okay? These are enormous differences. What we call the player strategy, which was a combination of two. Well, did you check off negotiations and did you check off what we call blocking? In other words, were you trying to block the other guy in order to pull him into a negotiation? So it's blocking and negotiations. Similarly, we find in complex 61 and less than half of that in discrete. A fences strategy, which we characterized as blocking, but you weren't interested in using the patent for negotiations. You just wanted to block a substitute. You didn't want to talk to these other guys. Okay? What were the differences there? In complex industries, 11%, okay, pursuing what we call the fences strategy versus 45%, more than 4 times as great in discrete product industries. Okay? I got to say, though, that although these differences are significant and certainly accord with our intuition, these are still very coarse distinctions. And there's still a lot of heterogeneity of uses, even within industries. In fact, the medical device industry is a hard one to peg one way or another, quite frankly. So this obscures a lot of interesting stuff going on in the details. But even with that, these differences are very, very clear and very sharp. Okay, so what might be some social costs of strategic uses of patents in complex product industries in particular? And I highlight that because that's really been occupied the attention in some policy circles. First, as I said before, this kind of mutual dependence, this not patent racing, but patent portfolio racing, can engender these sorts of arms races, which in turn might raise the cost of innovation. Okay, they may be, though not necessarily, associated with greater litigation, and they might yield patent harvesting. What do we mean by patent harvesting? That means you're patenting inventions that you would have come up with anyway. Okay, so that would suggest, well, what's the purpose of a patent in that kind of situation if you would have really done the R&D in any case? Perhaps more importantly, portfolio races might also deter entry and the innovation that may come with entry. How does that work? This has been also the subject of litigation and various antitrust actions. There's a convention in telecom and notably semiconductors of trading like for like. Okay, it's the usual suspects sit down to the table, they make deals. But guess what? If you're a little guy and you have 2 really valuable patents and you come up to them and say, okay, these are good, want to pay a license fee for these, they'll say no. Okay? They won't, they don't depend on you for access to your technology other than those 2 patents. They'll say, we'll invent around you, and if we infringe you, sue. Okay. And indeed, you could well imagine to the degree that that behavior is significant, and that's an empirical question, whether it is significant, and that's been, as I've said, the subject of a fair bit of litigation. But to the degree that that is pervasive, it surely constitutes a barrier to entry. Okay. And the bottom line then is that if, hey, in these kinds of industries, patents might play little role in stimulating innovation to begin with, then some of these other costs begin to loom much larger. Okay, but mind you, I'm an economist, right? And we all know that economists have two hands, okay, on the one hand and on the other. There's some benefits to these strategic uses as well, namely that with extensive cross-licensing across incumbents, you have greater information sharing, enhancing the efficiency of R&D. Also, what you likely do in that sort of situation is avert license stacking and the possible breakdowns in negotiations over rights that were really highlighted by Heller and Eisenberg as the anti-commons problem. I mean, if you have an anti-commons problem in biotech, you've got it in spades in semiconductors. Yet we seem to observe that semiconductor technology seems to move along, I'd say even pretty rapidly, by gosh. In this sort of setting of negotiations, these sorts of possible breakdowns, et cetera, are certainly averted. Also, realize that these sorts of strategic uses, even deterring entry, yields a profit. Maybe not the kind of profit that we think about when we think about patents, at least at first cut, but it yields a profit and therefore may indeed provide a positive incentive to do the R&D to begin with. So they're offsetting arguments here. Okay. Now, did I just? Okay. Yes. I don't know what is it didn't do this on my machine. Don't you hear that often when people have these sorts of problems? Okay. Yeah. 20. Okay. Go to the next one. 20. The possible benefit. So 20. Right there.
20?
Yep. That's it. At the bottom. It's always good to have a break. Any questions thus far? No? Okay. And this runs until about 5:45. It's an hour and a half. Is that okay? Mm-hmm. In another study, we looked at what we called the quid pro quo of disclosure. And patents are supposed to promote innovation two ways. Essentially strengthening appropriation of profits due to innovation. On the other hand, this disclosure function is supposed to really also contribute to innovation and technical advance. It gets the information out there that others can build on, et cetera, presumably without infringing your patent. That function is often overlooked in US policy discussions and raising a question, do these patent disclosures actually importantly affect innovation? Okay. Do other firms really read one another's patents for purposes of other than simply trying to invalidate them? Or are they trying to learn something from these things? So what we did to probe this, because we had a hunch that they are used differently, and this function is a bit different in Japan, is we compared patenting and related information flows in the US and Japan. Okay. Now, is that? That's good. What are the importance of R&D related information flows? Let's put this in a broader context. It can save on duplicative R&D. You can achieve complementarity effects, that is, learning what the other guy does makes your R&D more productive. Okay. It indeed can promote entry, though it comes at a cost of diminishing appropriability, that's sure. But in empirical literature, we actually know from Grillicus and Mansfield, the work of some others, that such R&D information flows that economists call R&D spillovers contribute importantly to national productivity growth. And this is a key finding in the literature, suggesting that this function is potentially an important one. I should say, though, that luckily we don't rely just on patents to achieve those R&D spillovers. But in general, those flows are very important in stimulating productivity growth in this country. So we tried to look at essentially the broad question of, let's compare between Japan and the US, putting aside the question of patents for the moment. Are information flows across rivals greater in Japan? Are information flows across rivals greater in Japan or different in Japan than in the US? We had any number of measures for this. First, we asked, whether information from the R&D activities of rivals suggested new R&D projects, or did such information contribute to the completion of existing R&D projects. We found a significant, and actually about a 20% greater effect with regard to suggestion in Japan than in the US, and about a factor of 4 or so with regard to completion. Then we asked, when are you first aware of a rival's major R&D project? And we provided them with different kind of qualitative periods in the innovation process. The initiation of the project, during the research stage, during the development stage, or at product or process introduction to the market. Okay. Here in Japan, we learned that 44% of respondents were aware prior to the development stage. In the US, only 16% were aware of the project in question prior to development. Again, another measure confirming the main point: these information flows are clearly thicker across rivals in Japan than they are in the US. Moreover, we also learned, you would think, well, if these information flows across rivals are greater in Japan, wouldn't you think appropriability is less? The ability of firms to actually profit from their inventions, shouldn't that be less? Well, again, like I told you, our respondents, in general, firms don't know what the returns to their R&D are, period, okay? But what we use for a crude measure for this is we said, well, tell us how long it takes for both separately for product and process innovations, for patented and unpatented for each of those. How long does it take for a rival to come up with either an imitation or a substitute for your innovation? For unpatented and patented process and product innovations, the imitation lags were indeed longer in the US by 40 to 80%. And if you believe that this is a reasonable measure of the returns to innovation, one could say, hey, yes, appropriability is surely greater in the US than in Japan. Okay, but why is there more information flow and less appropriability in Japan? We suggest that patents may be key, okay? And there are reasons why we suspected patents should be key. First, there's a different system of priority in Japan than in the US. In Japan, it's a priority to first to file, as it's called, rather than first to invent. That means that there's an incentive in Japan to get that application over the transom of their patent and trademark office sooner in the innovation process. Second, at the time of the survey, and this has changed since November 2002, that there was automatic disclosure after only 18 months after the application in Japan versus upon issuance in the US, which was typically greater than 18 months and often substantially greater than 18 months. So that meant that not only was this patent applied for earlier in the innovation process, it was disclosed sooner. Okay, then, and I actually think this is the most important thing. Who said? Was it Boswell, Samuel Johnson, hanging concentrates the mind or something of that sort? Okay. In Japan, you have a system then, when the survey was administered, of pre-grant. Now it's post-grant opposition. Your best chance for invalidating a rival's patent in Japan is actually via an administrative procedure, not in the course of litigation. Okay, that's your best shot. And at this time period in Japan, actually, you had a laying open of the patent application. Rivals could read this. And at that time, the examiners would actually use those opinions and that information to figure out whether they were going to issue the patent to begin with. What does that do? That provides a pretty strong incentive to pay very close attention to the patents of your rivals. Okay, so that might be already one reason, or one set of reasons why you would think patents would play an important role, a more important role in information flows across rivals. For the sake of time, I'm going to jump through this a little bit. But the other point is there's another reason in Japan. What is it? It's that patent claims are interpreted more narrowly, And by a factor of 3, there are fewer claims in Japanese patents than in US patents. What does that mean? That means there are more patents per commercializable product, et cetera, in Japan than in the US. That means, in turn, that the kind of reasoning that I laid out before, okay, there are more patentable elements per commercializable product in Japan across the whole manufacturing sector than in the US. Okay, what does that mean? That means that this incident, this phenomena of mutual dependence and the cross-licensing negotiations and bargaining should be more pervasive in Japan than in the US, and we should see that showing up in our rationales for patenting. Remember the very large differences we showed between kind of discrete product industries and complex and uses for negotiations, uses for fences, et cetera. Well, what's that look like in Japan? Negotiations. Use for patents for negotiations, 84 and 86% between the two types of industries. Okay? What I called the player strategy before, 83% and 81%. Again, patenting to block complements, where you have that phenomenon in the, typically in US complex product industries. Fences. You're patenting to really stop the other guy from coming up with substitutes for your core invention. How often do they pursue that sort of strategy in Japan? Hardly ever. Block, okay, the fences strategy in discrete product industries, only 11% and 7% in complex product industries. Okay, so what do you have in Japan then? What you have is this norm of information exchange attendant upon this bargaining process across rivals. And that cuts across the entire manufacturing sector. As a consequence, for that reason, as well as the sorts of policy differences that I laid out before, one would expect patents to play a much more important role in affecting information flows. Okay, what do we find? In fact, we compared channels of R&D information flow across rivals in the two countries. The top 5 in both countries were patents, informal information exchange. I called it that to avoid any suggestion of antitrust violation, by the way. I don't think they would have checked off yes to yes, you talk to one another all the time. Products through reverse engineering, publications, public meetings, and conferences. But what's key is that of these 5 top channels in both countries, one stands out as much more important in Japan, and it was the most important channel in Japan, much to our astonishment, scoring 30% higher than the next most highly ranked channel in Japan, while in the middle of the pack in the US, and its absolute score compared to the US was 70% greater. So given the cross-cultural differences, et cetera, I tend to believe the sort of relative differences more than the absolute. Okay, so what we conclude from that study then is not only technology, but policy and norms associated with the number of patents per product affect uses of patents, and these uses, such as cross-licensing, affect these information flows. But you might say, who cares? Okay. Then you'd say, well, you know, appropriability is less in Japan. Wouldn't that suggest that R&D is going to be less? In fact, 2 reasons why that may not be the case. In another study in the US, we found a positive effect of R&D information flows on rivals, this complementarity effect, offsetting an inability to protect or appropriate rent. So there are these offsetting effects. And I don't know why this is true yet. But interestingly, the R&D intensities on average in Japan compared to the US, still true. But at the time of our survey, it was almost double in Japan than in the US. Okay, by R&D intensity, I mean R&D normalized by firm sales. So, if this appropriability effect is so great, why are we seeing this? So it just puts the question in play. But I think the main point is what we're trying to do is put the issue of disclosure, okay, in play in US policy discussions. But then there's a follow-on question, which leads to the third study. do patents promote the progress of science in the useful arts, per its rationale in the Constitution? None of the studies that I've yet described tell us if that's true. And as I pointed out before, the fact that patents are relatively less important makes that question really cast that question all the more saliently, if you will. What happened there? Okay. In this is an exciting machine that I have here. In general, the impact of patents we've talked about on the appropriability incentive. You might have an indirect impact that should also be considered in studies of whether patenting induces more R&D. Because, hey, you know, if a patent is stronger, that doesn't mean just your patent might be stronger. The other guy's patent might be stronger. Okay, and what does that do to your incentive? That has to be considered. Moreover, as I pointed out, that particularly in cumulative technologies, patenting may reduce incentives for follow-on R&D, and then you have this spillover effect that we've talked about as well via patent disclosures. Okay, so in this study, we conducted a two-stage analysis to examine, I said the effect of R&D. That's not right. It's the effect of patenting on R&D. I'll change that for the web version that gets that's out there. And what we did was we estimated the average patent premium, which we defined as the proportional increment to the value of innovations realized by patenting. So we estimated, in essence, what's the value of an invention absent a patent, and then what's the increment to that value if that invention is patented. That's a very difficult thing to do, as I and my co-authors discovered. And so we estimated that for what we call typical innovations, that is all innovations, and for patented. So the question is, well, what's the average premium across all inventions, patented and not? And then if you've patented something, what's the premium on something that you've actually patented? And then we go ahead in the second stage and analyze the impact. We do a what if you increase this premium, what's the effect on incumbents' product R&D and patenting behavior? This analysis ignores a few things, namely the things we talked about before about effects on entry, and something I didn't talk about, it also ignores the effects of patenting on markets for technology, that is, for example, licensing, which can actually enhance the efficiency of R&D and innovation within industries. The main, is this? Okay, I'm skipping a slide, but we don't have time to, so let me just tell you what key considerations in this analysis are. Essentially, you have to recognize that R&D and patenting are driven by many of the same variables. Moreover, that the one will affect the other, particularly in a cross-sectional setting, which is the kind of analysis we're doing. Moreover, in this analysis, you want to account for both the two main effects, which we do, which is the effect of patenting on appropriability, but the effect of patenting as well on information disclosure, and therefore spillovers benefiting the other guys, which in fact can detract from your ability to appropriate rents. I will, okay, again, we're basing the analysis. This is now going every other slide, so this should be pretty exciting. That's right, exactly right. You've got it going here. That's right. That's right. I forgot. I'm in a law school. That's right. But wait a minute. They're not that sophisticated in IT. So we have some, among a busload of other data elements, some of the more interesting elements that allow this analysis to go is firms' self-reported patent propensities, percentage of innovations for which they report to apply for patents. We have numbers of self-reported patent applications, and we have that patent effectiveness measure that I talked about before. We're back to now going one at a time. What is, I'm going to skip the very gory details and provide some basic results. Our estimates of the patent premium by industry. If you see a premium greater than 1, that means there's a positive expected return to patenting. We have conditional, meaning this is for the inventions that were actually patented, and this is across all inventions. For the aggregate sample, indeed, we find, consistent with the prior literature, that on average, it is not worth patenting an invention. Okay? But for those inventions that you do patent, indeed, there's a substantial positive premium on average. Okay? Reflected in the number greater than 1, 1.53. We see interesting cross-industry differences as well. Not surprisingly, in drugs and medicines, biotech, and medical instruments, these are about 1, a little less, a little greater. So that's where the premium is surely greatest. And in our sample, the premium was, at the low end, surely in semiconductors, making the general point that there's a lot of variation across industries. This provides a nice graphic by industry of the average patent premium and the conditional premium, where industries are defined at a fairly high level of aggregation. Okay. Boy, we just skipped some important slides. Okay, I need this one I need. In the next slide, I want to talk about the elasticity of R&D activity and patenting. It's slide 37. With respect to this patent premium. Okay, what does increasing the patent premium do to your R&D? Does it stimulate R&D activity, and how does that vary across industries? And wait a minute, if patenting is more worthwhile, a greater premium, you would expect patenting itself to grow. Okay, and in fact, you would expect to some degree the patenting of inventions that you might have come up with anyway. So you would expect some degree of harvesting. Thank you. So what do we see? In the aggregate sample, we see, in fact, and this is a result. I went in this with no axe to grind. Okay. I did not necessarily expect to see a positive effect of patenting and interpreted specifically in the context of the study of the patent premium on innovative activity. I did not expect to see a stimulative effect in industries like semiconductors. Okay, and much to my surprise, we saw and we observe a positive effect in industries like semiconductors. Okay, not just like, but semiconductors itself. Though we do see, right, a disproportionately greater response in patenting itself in semiconductors, represented in the differences in the changes in the ratio of patent applications to R&D. But the main takeaway from this slide is the result that patenting, again interpreted in the way that we're interpreting it, namely the premium does indeed appear to stimulate R&D activity broadly across the manufacturing sector, and even in those industries where you might have some significant reservations. Now, let me be clear about what we're not looking at here. This is just incumbents. So, for example, could this broad result perhaps go away if we understand the impact of the way patents are used, as I talked about before, on entry? Sure. Okay, so we're not considering the issue of entry, for example, here. There are other qualifications, surely, and any of you who've done this kind of analysis know that qualifications for this sort of work come by the dozen. Okay, so the implication is that we see a positive effect of patenting on R&D overall, even in industries such as semiconductors. We do find some amount of harvesting in all industries, but especially where the patent premium is lowest, as in semiconductors. Okay, and I highlight what we don't look at. We don't consider the positive effects of patents on entry. But by the way, we also didn't consider the negative effects, of patents on entry, but we didn't consider the positive effects due to the creation of markets for technology either. Okay, and that's important, even in semiconductors, okay, where you have the growth of a whole industry segment of essentially chip design firms on the strength largely of patent rights, though they cannot break into the integrated segment in that industry. Okay, so the conclusions. many ways to protect inventions, not just patents. So when you talk to folks about this, understand that there's a broader context here to understand what the policy or even managerial implications are. And while patents are not as featured as other mechanisms, such as secrecy, first mover advantages, they do, in our analysis, seemingly stimulate R&D broadly, though again, more in some industries than others. Moreover, from our analysis of Japan, we find that patent disclosures can contribute importantly to R&D information flows. We are now doing the same sort of study that I just reported on for the US, for both Japan and the US. We've got the data. We're doing it. Okay? And in the US, I should tell you that the spillover, the disclosure effect of patents in the US basically was imperceptible. Okay, so those disclosures had very little effect in the US. Our preliminary results suggest for Japan, consistent with our prior descriptive study, that those effects are actually significant in Japan. Okay, so you know that pertains to this point, and that patent disclosures can indeed not only contribute to R&D information flows, but in turn have a role in affecting R&D and the role of patents as well. We talked about the policy concerns raised by the player strategy for managers and policymakers, but I would say, and I'd end on that qualification, which is really to dig deeper in this area, we need to probe more and understand more the effects of patents, particularly on industry entry and emerging, because they really continue to emerge, emerging markets for technology. Thank you.
Well, I want to thank Professor Cohen for a wonderfully engaging and even despite the fact that you went every other slide, it was very articulate and clear, your presentation. I unfortunately have to leave, so I'm going to have Professor Jamie Boyle take over in terms of calling on people for questions. So,
absolutely.
Okay.
Thank you, Arti. Although I think Wes is probably more than capable, so questions for Professor?
Sure. Maria, yes.
That was very exciting and
Great, thank you.
informational. Very nice presentation. I just have maybe a thought about the semiconductor industry. Seem to always be at a kind of an outlier to some extent. And semiconductor industry traditionally has protected the intellectual property, the use of copyrights, because the layouts can be copyrighted and protected through that mechanism, and less frequently used the patenting as that.
Semiconductor industry?
I believe so.
Okay, let me clarify this. Yeah, you're talking about perhaps the software industry. Okay, semiconductors. You do have a sui generis form of protection of design registration, which is probably what you're referring to. In semiconductors, design registration has been found. I forget what year that passed. The mid '80s, basically. 84, right? Has been a hollow shell of protection, and really not employed at all. Okay, but what is interesting is what I alluded to before, is you have firms like perhaps the best known Rambus. Okay, basically firms that design chips in essence. Their whole value is premised on their intellectual property, much more so than any physical assets. And patents have provided the basis for enormous growth of design firms in that industry. And if you'd like to see a very nice paper on that, I should have brought a copy of the book. Just recently co-edited a volume called Patents in the Knowledge-Based Economy that I co-edited along with Steve Merrill, and there's a great book on patenting in semiconductors where it really does track the growth of these design firms. But what's interesting there is that these folks can't break into the segment dominated by Intel, IBM, and so on. So yes, you have patents providing a basis for entry even in semiconductors, but again, it's entry of a limited sort, though very important and arguably very beneficial from a social welfare perspective. Sure. Yes.
So, quick question. In your surveys to U.S. corporations, did you inquire how much they actually either encourage their employees or actually have a policy of going out and looking at the patents filed in the patent office?
Yeah.
I'm coming from industry, and one of the things that seems to happen is that patents are kind of this right-only thing. They're written and then nobody ever looks at them again.
No. See,
Discouraged
right.
from doing so.
Yeah. Well, again, I would let me guess that you don't come from the drug industry. Okay. Let me guess, maybe IT related. Okay. Right. No, that's right. Exactly. That's right. and your birthday is. No. Well, and the reason for that is, well, one, let me answer the initial question. The initial question is, did we ask about this beyond asking our respondents about the role of patent disclosures in providing useful information? We did not. We did not ask them, do you encourage your employees, et cetera, technologists to go out and look at these things? We did not. But we clearly have measures of the importance of patents for disclosure and information flow. But from other work that I've done and presentations that I've heard in the course of working with the National Academies of Science, Engineering, et cetera, on this, is we find something pretty interesting in just that issue. In the drug industry, you read patents. You just want to know just as soon as possible about some other guy's patent on a related compound, et cetera. Okay? In the semiconductor industry, it is not uncommon, shall we say, for management to say, do what you're going to do, and we'll let our lawyers take care of it at the back end. Okay. And that really speaks to the issue of kind of this convention of freedom to operate. They don't want to be bothered, and it's so complicated, and there's so many, there's so many infringements and potential infringements that these guys just don't want it to slow them down. Okay, so they arrive at these deals and understandings, et cetera. So in other words, the kind of behavior that you're talking about, the answer differs depending on the type of technology and the type of industry, and the kind of very broad distinctions that I've drawn here provide the first, at least at a first cut, a little bit of insight into addressing the question. So that was actually quite. I've heard people from the semiconductor industry stand up in webcast forums, okay, and say, we tell our guys to ignore this stuff. Just go right ahead. Okay, it's not a secret. Jamie.
I'm interested in one of the slides you were pointing out that this relates to the impact of norms, sort of intra-industry, cultural norms and so forth, and the way in which those have impact on innovation. And there was a study a while ago by Alan Hyde on employment practices in Silicon Valley, where he found that despite the fact that California had on the books an extremely strong set of laws which would have apparently could have been used by employers to prevent employees taking knowledge, implicit, non-patentable knowledge, out of one firm and taking to another. In fact, the practices were, at least through the 80s,
largely ignored.
Ignored, and even the contrary.
Right.
The norm was quite the contrary. So,
right.
As I was thinking about this, and also thinking about how a firm like Red Hat might respond to your survey.
Mm-hmm.
I mean, obviously, I could see how they would respond. They'd say, well, we rely on being first to market and tied services. That would be their strategy.
That's right.
To some extent, and it's hard to sort of put this in words, but to some extent, the form of the question that we ask in patent policy to begin with is premised on the notion of the public goods problem, and that we have to limit the appropriability of information in order to encourage R&D. That's the starting point, and then we kind of say, now how do we do it, right? And what I'm wondering is, as you were going through particularly the cross-cultural aspect of the comparative aspect of your studies, did you get any evidence of really almost sort of completely different attitudes to how one how one encourages innovation. Now, I mean, I can't remember the wording of your question. I think it was, how do you protect innovation? What's
Right.
the most technique in protect?
Now,
I
what's
was
the
wondering-
most, indicate what percentage of your innovations you consider each of the following mechanisms to be effective in protecting the competitive advantage
Yes.
due to that innovation?
Right, and so this is, empiricists always get asked the question, well, what might have happened if you'd asked a different question?
Oh, sure.
This may fall in that area. But I was wondering, did you get any sense, and the closest that you came to it in your talk was the discussion of the role of disclosure in Japan, in encouraging, sort of cross-fertilization. Did you get any sense of people within either industries or across countries thinking that one of the primary, innovative strategies that they relied on, that they had to maintain, were sort of innovation flows across, relatively free innovation flows across companies, across sectors, which they harvested and then relied on kind of speed to market, trademark type services, reputation for quality, the
Right.
mana or charisma of the firm or whatever. Those cluster which are less exclusive than
Right,
some of your
right.
other strategies.
Well, in fact, in Japan, as implied by some of my slides, to put it perhaps most simply, patents are used as a vehicle predominantly for inclusion rather than exclusion. Okay, they are used to assure, firms use them to assure themselves of a place at the table. Okay, and the kind of norms that we talked about for semiconductors are pervasive there and even carried to much greater extremes. And in fact, Japan passed these policies, or originally developed, actually building on the German model early on, actually in the face of growing Western investment in Japan. And they really wanted to design patent policy that would confer access to Western technology, first and foremost. Then they woke up and said, hey, we're applying these laws to ourselves, and guess what? Okay, and in fact, even in pharmaceuticals, they're very, very explicit. My co-author, John Walsh, has interviewed pharma executives, among others, and they say, well, we really like patents that are very, very, they call it the sashimi approach, very, very fine-grained, and therefore you need a lot of patents on the same product, because that gives us access to everybody else's stuff, and particularly that gives us a leg up competitively. So I think then that clearly there are different norms. Also in Japan, there are other issues. It's only recently the damage awards have achieved any modicum of value at all, and I think the largest damage award in Japan is still on the order of only about $30 million. That compares to the famous Polaroid Kodak in the vicinity of 900 million, and that was just the cash part of the settlement. So you do have systems, and you could say, well, is that a system? Then the interesting question is, right, does that kind of system, which Japan is moving away from, I should say, they're adopting more and more of the Western policies, but does that kind of system, is that more effective in stimulating and encouraging innovation than our patent system? Don't know, so the answer to your question is yes. There is another system with very different notion of norms and the public domain associated with this, though it's a coercive public domain. It's not because everybody just wants to share. They realize they've got to bash one another over the head to make everybody share. Okay, but then what you also don't have is litigation at the back end. But then there's the follow-on question is, well, are they better off as a consequence? And that's a big question that I certainly don't have an answer to as yet.
Can we maybe continue the questioning at the reception? We have a reception outside.
I'm happy to continue to do that. Whatever the timing is, I'll let you guide us. That'd be great. Good. Thank you. Thank you very much.